This is people of the city of Cadillac versus Madison, Leanne, Reese, case number 26-270D. Ma'am, did you read and sign this advice of rights form?
Yes, I have.
The contact information on the back, is that accurate?
Yes, I have.
Did you have the opportunity to meet with somebody from the defender's office today?
Yes, I have.
I have a complaint that alleges that on or about December 30th of 2025 in the city of Cadillac in Wexford County, it is alleged in count number 1 that you committed the offense of operating while intoxicated. That is a misdemeanor with a fine of not more than $500 and or 93 days in jail, with suspension or revocation of the driver's license, vehicle mobilization for not more than 180 days, and ignition interlock during any probationary period. Do you understand those charges and the potential penalties? Ignition interlock, which means you could be ordered to have a blow machine installed in the car before the car will start. Do you understand those possible penalties?
Yes.
You have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one to be appointed to represent you at public expense, you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I would like to try to hire an attorney.
The court then will enter a not guilty plea on your behalf and will set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. Do you have a question about that? Okay. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I do not show a criminal history for the defendant. I don't have a praxis because she's a walk-in. But bond was set at $250 over the weekend. That has been posted. Any comment regarding bond, Mr. Harrison?
Yes, I think the 250 is more than sufficient bond for her. She has no prior criminal history. She is gainfully employed, although it's only been a couple of months, at the Dollar General in Chase, and she lives in Reed City. That would call to mind that testing may become an issue here if the court deems it necessary to do so. I believe she will be able to find a local testing facility right there in Reed City. Or else if the court deems necessary, she can go on the dailies. We don't believe that the PBT, actually the PBT that she recalls was 0.131. And I think that was also written on the ticket, so we're aware of that as well. Thank you.
Thank you. Ms. Lawrence?
This actually was an accident that occurred when it was driving along Sunnyside Drive, lost control of the car. It looks like it went off the roadway and actually rolled and ended up flipped over essentially. There was a PBT done that came back to 0.131. We are still waiting on a blood draw in this case. The level of intoxication as well as the accident, I would ask for random alcohol testing.
Was it a single car accident?
Yes.
All right. I will continue the bond as previously set. The defendant does present herself here today, so I don't find her at flight risk. Ms. Reese, as a condition of your bond, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crime. I am going to order that you not consume any alcohol and you'll be subject to random testing. I'm also ordering no controlled substances, including recreational marijuana, and you'll be subject to random testing for those as well. Do you have any questions for me about your bond conditions?
No, I do not.
All right. You can go out to the front window where you checked in, get a copy of your next court date. Then you'll need to go downstairs to community corrections and get signed up for your testing. Now, you need to make sure that if you are able to hire an attorney, that they're aware of your next court date, because until they actually file an appearance with the court, they won't receive any communication from us. Now, if something happens that you're not able to retain a lawyer, but you would still like representation, you can always make a request to make a referral to the public defender's office for the appointment of a public attorney. Do you understand that?
Yes, I do.
Okay, you can go out to the front window where you checked in.
I don't think she turned in advice of rights.
Returning the signed advice rights to the court and the clipboard to the court clerk.
Thank you. All right, this is the case of the people of the state of Michigan versus Dusty Lane Rodriguez, case number 26-24-SD. We're here for an arraignment. Ma'am, did you read and sign this advice of rights form?
Yes, sir.
The contact information contained on the back, is that accurate?
Yes, sir.
Did you have the opportunity to meet with somebody from the defender's office?
Yes, I do.
I have a complaint that alleges that on or about January 1st, 2026 in Herring Township of Wexford County, it is alleged that you committed the offense of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $100 to $500 and or 360 hours of community service, rehabilitative programs, vehicle mobilization and mandatory with a prior, and reimbursements for cost of prosecution and governmental expenses. Do you understand those charges and the potential penalties?
Yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one, would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request the appointment, sir.
All right, court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, a $250 bond has previously been posted. In 18, I show there was a 4A case. And then in 99 on state, it looks like there was a battery case. Praxis scores her at a risk level 1. Any comment regarding bond, Mr. Harrison?
Yes, Your Honor, even though she shows a Traverse City address, which is in fact her permanent address, mailing address, et cetera, et cetera. She's currently residing here in town, so it's not going to be an issue for her to return to court. As you can see, she has no prior criminal history. She does have, despite the fact that she has some formal training in nursing, she is currently unemployed. And in the sort of transition in her personal life as well. I don't think any of that is going to prevent her from appearing in court or participating in the defense of this matter. We understand there was a 0.11 PBT, which was a huge surprise to her. She's not much of a drinker. That notwithstanding, Your Honor, she is fully aware of the gravity of her situation and doesn't take it lightly. Thank you.
Thank you. Ms. Rodriguez, Mr. Harrison said you're staying here in Cadillac. Is the Traverse City address where you'll still receive mail then?
Yes, sir.
Okay. Any comment regarding bond, Ms. Lawrence?
Yes, thank you. This started out as a traffic stop for crossing the center line. There was a PBT done, I believe it was actually 0.133. Are waiting on blood in this case, and the defendant was also driving on a suspended driver's license at the time. Given that, I would just ask for random alcohol testing at this time.
Court will continue the $250 bond as previously set. She does present herself today, so I do not find her as a flight risk. However, Ms. Rodriguez, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I also find it's appropriate in this case to order no alcohol, along with random testing, no illegal controlled substances, including recreational marijuana. Then you'll be subject to random testing for that as well. Okay, you can go out to the front window where you checked in, get your next court date. You'll have some paperwork to fill out for the defender's office, and then you'll need to go downstairs to community corrections to get signed up for testing. All right, thank you.
Thank you, Your Honor.
Mr. Harrison, I have a fail to appear. Do you?
We can do that real quick. I don't, it's up to you, Your Honor.
Yeah, let's just wrap up. Yes. Court calls the people of the city of Cadillac versus Evan Garrison Asham. This is case number 26-230M. We're set for an arraignment. Defendant does not appear. I have a note from community corrections that the phone number has been disconnected and he was given a PR bond in the interim. He does not appear by Zoom. Have we had any communication with him?
None.
Our office has had none. Ms. Lawrence, is yours?
No.
I assume we haven't as well.
Correct as well, Your Honor.
Does have a Skyview Circle address in Cedar. The count is trespass, so the court will issue a show cause.
Thank you on behalf of Mr. Asham.
That completes the docket. That completes the docket. We're adjourned. This is case number 253078FY. Mr. Wright appears. Mr. Carnes, is this your case?
Yes, sir.
All right, Mr. Carnes appears on behalf of the people. Mr. Wright, it does not appear that an attorney has been appointed to you yet. Sounds like maybe some paperwork didn't get sent over in a timely manner to the conflict administrator. So we will go ahead and reset this for another probable cause conference. Set it next week and see what happens. All All right. You can go out to the front window where you checked in, get your next court date, and we'll keep our fingers crossed for you, all right? All right, just a reminder, your bond conditions continue.
And then the next one.
Court next calls the people of the state of Michigan versus Jeremy Joe Powell. This is case number 255159FY. Mr. Powell appears, and who has this on? Ms. Carey has this on behalf of the people. Mr. Powell, you're here for a probable cause conference, and when you were arraigned, you had indicated you were going to hire an attorney.
I tried, Your Honor, getting hold of Bill Barnett
Okay.
all week. I went to his office 3 different times. His door's always been locked after I call him, and when you call his phone number that's online, it goes straight to a message saying that you have to put a PIN number in, and I could not leave a message, so I've been really trying.
So my question then is, do you want to request a court-appointed attorney for right now until you're
Right
able to
now,
get a
yeah,
hold of
it'd be
Mr.
fine,
Barnett?
too.
The court will then make referral to the public defender's office for the appointment of an attorney. We will reschedule this for another probable cause conference next week. Any objection to that, Ms. Carey? All right. Mr. Powell, you can go out to the front window where you checked in, get your next court date, and you have some paperwork to fill out for the defender's office.
Thank you.
All right, thank you. All right, court next calls the people of the state of Michigan versus Christopher Lee Bowler. All right, this is case number 255160FY, the people of the state of Michigan versus Christopher Lee Bowler. Appearances, counsel.
Jane Carnes on behalf of the people.
Robert Hartzell for Mr. Bowler, who joins me at the table, Your Honor.
And we are here for a probable cause conference, and there has been an amended complaint filed in which we'll have to arraign Mr. Bowler on. So we'll go ahead and do the arraignment first. Mr. Bowler, I have an amended complaint that alleges that on or about December 23rd, 2025, in the city of Cadillac of Wexford County, it is alleged in count number 1 that you committed the offense of police officer assaulting, resisting, or obstructing, in particular, Sergeant Jeffrey Izzard of the Cadillac City Police Department. That is a felony punishable by up to 2 years in prison and or a fine of $2,000, and consecutive sentence may be imposed if it happened in a place of confinement. Count number 2, the magistrate did not find probable cause for. Count number 3, or obstructing a public officer, in particular, Agent Stephen Saladay, that is a 2-year felony punishable by up to the 2 years in prison and or a fine of $2,000, and consecutive sentence may be imposed if it happened in place of confinement. I'm sorry, consecutive sentence may be imposed if for any other conviction arising out of the same transaction. In count number 4, it's alleged that you committed the offense of public officer assaulting or obstructing, in particular, Agent Sean Van Ackmel. That is a felony punishable by 2 years in prison and or a fine of $2,000, and consecutive sentence may be imposed for any other conviction arising out of the same transaction. Additionally, the people have charged you as a habitual 4th offender, which means that you have at least 3 prior either attempted or completed felonies in your past. That makes each of those 2 years punishable by up to 15 years. Do you understand that? You do have the same rights that you had when you originally arraigned on this case, in particular, the right to remain silent and anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time, and the right to be represented by an attorney at all phases throughout this process. I know you have requested the appointment of an attorney. Mr. Hartel has been appointed, so we will go ahead and continue that appointment. And we will enter a not guilty plea on your behalf to the amended complaint. So that brings us to the probable cause conference. Counsel, is there any resolution in this case?
No, Your Honor.
All right. That means we'd be scheduled for a preliminary examination.
Yes, Your Honor.
That would be set for next week. Is there anything that's going to hold that up?
I'm aware of, Your Honor, nor myself.
All right, then we will go ahead and we will continue this for preliminary examination next week. Anything else for the record, counsel?
Your Honor, if there may be something from the people, I'm not sure, but the defense would ask if we could address bond.
Any objection, Mr. Carnes?
No, Your Honor.
Your Honor, I do realize there have been added counts and not counts taken away. However, I have been in contact with the client's parole agent, probation agent, Miss Simmons, and she has advised me that if he were, by the grace of the court, able to get a PR bond or otherwise post bond, which we know we can't afford to post. But if the court were so kind to do that, it would spark the proper process for the parole board to have to give him a proper review, decide what they want to do with that situation. He is motivated to deal with those scenarios. And just so the court is aware, I do believe that parole hold would still be there. He wouldn't be really released. There's some academics to it, but he is motivated to resolve that portion of it at least. And I do believe that would help with plea negotiations and other aspects for him to know what's going on with the other elephant in the room, if that makes sense. I realize this isn't a traditional bond motion type request, but I will still ask the court to factor that in. It is important to him for the court to consider. Thank you.
I just want to make sure I
Yeah.
follow. So you're asking for a personal recognizance bond, so the parole board has to deal with him.
Yes.
And
that's
then
correct.
assuming they don't flop him, he's just released, correct?
Well, he would still have to resolve what's going on with them. He wouldn't be immediately released, if I understand correctly, but even if he were, he would still have all the supervision that comes with parole. So it's not like he would be released without any form of supervision. Yes, Your Honor.
All right, thank you. Mr. Carnes?
Your Honor, he had the supervision that comes with parole when these charges arose, so it does seem that he's still a threat to community safety when he's on parole. I'd ask the court to keep on where it's currently set.
Have you scored him in this case yet?
Not yet, Your Honor.
What was he parole for? Was it the resist and obstructs from 23?
Yes, Your Honor, that is what would make sense, is would be that he would be on parole.
Do you need a minute, Mr. Hartel?
No, he was just sideline.
Anything else, Mr. Hartel?
No, thank you.
All right. We're going through the bond conditions in 6.106. The court is to include or look at the prior criminal history. In 19, there was a false report of a misdemeanor, 19, operate without security, and 20, domestic violence, assault and battery, abandoned cruelty to animal, malicious destruction of property, 200 to 1,000, and attempted resist and obstruct. And 21, attempted to interfere with electronic communications and domestic violence. 21, possession of meth. 21, malicious destruction of a building, 200 to 1,000. 21, use of meth. 22, possession of meth. 22, resist and obstruct. 23, 2 resist and obstructs. And in 20, resist and obstruct a conservation officer and use of methamphetamine. Record of appearance, fail to appear, flight to avoid prosecution. I don't have anything in front of me regarding fail to appears. However, if I recall correctly, this arose out of a parole check, correct, in the DOC office?
Yes, Your Honor.
And the defendant allegedly put his head into a wall and fought with officers, took 2 male corrections officers to retain him, broke a desk, and bounced his head off a patrol vehicle a couple times.
Yes, Your Honor.
Mental condition, character, reputation for dangerousness. The defendant has some assaultive crimes in his past, several resist and obstructs. So I think that goes to reputation for dangerousness, seriousness of the offense. He is now facing a total of 3 resist and obstructs as a HAB 4. He went to prison last time in resist and obstructs. So I do find the seriousness of the offense is there, along with a likely sentence, probably a trip back to the prison. Responsible members of the community, ties to the community, relationships, length of residence. I do know he is a longtime resident of the area, and any other factors that the court considers. The court set this bond on December 29th at $25,000 with the conditions that he not purchase or possess any firearms or weapons, not acting in threatening, intimidating, harassing behavior, and to comply with the Department of Corrections. By my count, the defendant has 5 either attempted or completed resist and obstructs in his past. He's now facing 3 more charges for the same. The bond will continue to be set where it's at. Anything else for the record?
Nothing else, Your Honor.
All right, thank you. That completes the morning document. We are adjourned.